I think my friends, my family, my colleagues would be shocked to hear me talking about anything political, anything having to do with this presidency. So this was probably a first-time event for everyone in my circle of the world. But there is the old truism that elections have consequences. And in this small sliver of the national agenda, being employment law, labor law, as I'm going to go through in the next 10 minutes or so, elections have, this election, as any election, has real significant consequences and has had for employers and employees. So I'm going to first talk about the National Labor Relations Board, and just 10-second background. We have in this country the National Labor Relations Act, the NLRA, which is an act to protect workers, employees' rights to organize, to unionize, to discuss, engage in concerted activity for their health and welfare benefit. The National Labor Relations Board is an independent federal agency which has judiciary-type authority to enforce the NLRA, the National Labor Relations Act. The National Labor Relations Act applies to every employer in the country, whether you're unionized already or not. That's a common misconception that it only applies to unionized employers. So the reality is that the NLRB has something to say about every workplace in the country, whether unionized or not. So following the election, in 2017, President Trump appointed two Republicans to the NLRB. The NLRB is a 5-person board, subject to appointment by the president, subject to confirmation by the Senate. So with President Trump's 2 appointees, the board is now made up of 3 Republicans and 2 Democrats. The new chair of the board has 30 years experience representing companies in private practice. If you're an employer management side person, you may be happy with some of the actions that have quickly been taken at the NLRB under the new administration. If you're a union person, a union organizer, an employee rights person, you'll be less happy than that, than the employer side. I will say here at Davis Malm, we do both sides of the aisle. So we represent employers, we represent management, we represent employees. So we have no political hunt in this game. The new general counsel of the NLRB, when he came in, quickly issued a memo signaling his intention, identifying several Obama-era decisions that the new board and that he in his role as general counsel was going to seek to readdress, including handbook rules, employee rights to use company email systems, and the doctrine of joint employment. For those of you who have attended our annual employment law update in years past, we have spent, I think, a couple of times at least, we've talked about employer policies, social media policies, handbook policies, and the impact that the NLRB rulings have had on employment policies. And it's been hard to make sense of it over the years, but there's been a lot of policies that have been struck down by the NLRB, basic employment handbook policies that the NLRB has found not to pass muster under the NLRA. And we're going to talk about where those decisions stand now, because there's been a significant reversal. So the general counsel issued a memo, and there have been already several Obama-era precedents that have already been overturned, and you can be sure that more will come. So Section 7, just a little primer, of the National Labor Relations Act protects employees' concerted activity, which means when employees take action or engage in communications for their mutual aid or protection regarding the terms and conditions of employment. So it includes such things as picketing, as union organizing campaigns, or even more than one employee is getting together talking about compensation, their salary, the employer's pay practices, workplace rules, and employment policies. It's a wide range, but any of that, any such discussions, any concerted activity along those lines could be seen as being protected by Section 7 of the NLRA, again, whether or not you're a union employer. So it applies to non-union employees. So a policy, an employment policy, an employer policy will be unlawful under the NLRA if it explicitly restricts Section 7 activity, was adopted in response to protected activity, or was applied to restrict section activity. So over the last 8 years plus, the NLRB had been striking down any employer policy, and we're talking about policies like general employment law handbooks. If you're an employer, you probably have or should have an employee handbook. And the NLRB had been striking down employer policies under Section 7 on the test that whether it could find that the policy could be, quote, reasonably construed by an employee as impinging on Section 7 rights. So it was a one-sided analysis by the NLRB under the Obama era. If a policy could be reasonably construed by an employee as impacting his or her Section 7 rights, the NLRB was striking down these policies, and that's what's called in legal jargon in our world the Lutheran Heritage Standard. That's the case in which that policy, that standard was developed, the reasonably construed standard. The board was not giving due consideration to an employer's legitimate justification for the policy. And over the years, this led to, just to put it simply, nonsensical and irreconcilable results. For instance, policies that the NLRB struck down under the reasonably construed standard, including policies that advised employees to, quote, work harmoniously, was struck down. And policies that encouraged employees to conduct themselves in a, quote, positive and professional manner was struck down. Policy that prohibited loud, abusive, or foul language was struck down. Policies upheld under this standard, quote, no abusive or threatening language to anyone on company premises was upheld. I would challenge anyone to make a principled distinction between policies that have been struck down versus policies that have been upheld. Prohibiting conduct that not support the employer's goals and objectives was upheld. So it was difficult to evaluate for us as lawyers, for you as clients. What do people like? People like, I think, whichever way it comes out, people like consistency and predictability. We do a lot of handbook we write a lot of employee policies, employee handbooks here, social media policies, confidentiality policies, the entire range of employee policies. Over the years, clients would come to us and say, well, is this policy, is this handbook going to withstand scrutiny? And it's been very, very difficult, as you can see here, to answer with any degree of confidence and predictability as to what the NLRB, if challenged, would uphold and what it would strike down. So now in December of 2017, the NLRB issued the Boeing decision. That's what it's called. And that was the case. It was a case brought against the Boeing company. And the NLRB concluded in that Boeing decision that the, quote, reasonably construed standard is incorrect as a matter of law. So let me just talk a minute about what the Boeing decision was to put it in context. Boeing had issued a no camera rule within the workplace. And what that really meant was no camera rule, no camera use without express permission with warning. So Boeing, as we all know, Boeing is an aircraft manufacturer. We all know that. Boeing is also a defense contractor, a substantial defense contractor. Boeing deals with highly confidential, top secret, sensitive information in its defense work and in its aerospace work. Boeing facilities are targets of espionage. Boeing's facilities are targets of terrorist attacks or terrorist activity. Because of those interests, Boeing adopted a no-camera rule restricting the use of camera-enabled devices. And in this day and age, that includes every single person's mobile phone. Your iPad, your phones, PDAs, everything, every device that every person carries was subject to this policy while on Boeing's property. Now, the administrative law judge, an employee challenged the policy, claiming that it interfered with his rights to engage in concerted activity and take pictures on premises and establish workplace conditions. And the administrative law judge struck down the no-camera rule on the grounds that employees would reasonably construe, using the reasonably construe test, that the rule to interfere with protected Section 7 activity. The administrative law judge gave no weight to Boeing's security needs. On appeal, the full board struck down the Lutheran Heritage Standard. The board adopted a new analysis for evaluating a facially neutral policy. So here again, I want to emphasize what we're talking about only are policies that on their face are neutral. If a policy said employees cannot picket the premises, employees cannot engage in discussion about their salary, their compensation, the terms and conditions of employment, those on their face would violate Section 7. They would not withstand scrutiny. So what we're talking about are policies that on their face are neutral, but under the old Lutheran Heritage Standard, if an employee would reasonably construe it as impinging on their rights without any consideration to the employer's justification, that policy could have been struck down. So the new analysis that's now adopted is now called the Boeing Standard, is that any facially neutral policy will be evaluated for its nature, the nature and extent of its potential impact on Section 7 rights, and the employer's legitimate justifications for the policy. So, and then the board emphasized its duty under the NLRA itself and under Supreme Court precedent that there is a duty to properly balance between legitimate business justifications and the invasion of employee rights. That balance had gone out of whack in the Lutheran Heritage Standard. It's now been reinforced, and the full board overturned the administrative law judge's determination striking down Boeing's no-camera policy. This does not mean that all employer policies will be upheld. For instance, in a decision from last month, a NLRB administrative law judge was faced looking at a confidential information policy that prohibited employees from talking about salary information. That policy had been struck down under Boeing, but the judge found this to be a per se unlawful policy and so it found the policy on its face, the judge, to be a per se unlawful policy. So the judge didn't have to take it any further. But in light of Boeing and the newness of the Boeing standard, the judge took it further and said, well, I will now evaluate this under the new Boeing standard, and found that under the Boeing balancing test, in this case, this was a case against Lowe's hardware store, the judge found that Lowe's justifications did not outweigh the employee's rights to discuss their wages. So it's just a reminder that now that even though we have the new Boeing standard, which will require a consideration of the employer's justification, legitimate justification, that does not mean that every policy will be upheld under Boeing. And this was a good example of a facially invalid policy, which did not even meet, if you went beyond that, the Boeing standard. So, so moving forward, it provides us as lawyers writing policies, a little bit more predictability and guidance in in addressing your policies, and so you should all keep that in mind. The other big issue that's been impacted in the Trump era with the new board is the law of joint employment, joint employer status. Just a week or two ago, actually, on May 9th, the NLRB chairman referred to the joint employer standard as, quote, one of the most critical issues in labor law today. The joint employer standard determines the scope of employer liability in a number of settings, franchisor-franchisee relationships, independent contractor relationships, contingent worker relationships. All of those relationships, and then some, can be implicated by the joint employer doctrine, which that means that there could be an expansive scope of liability for unlawful activity. Substantial financial consequences for failure to pay compensation, misclassification of exempt status or independent contractor status, unfair labor practices, and breaches of collective bargaining agreements. So in a franchisor-franchisee relationship, for instance, you take a franchisor like McDonald's, it's got an independent franchisee who, at that particular location, the franchisee is setting their own terms and conditions of compensation, wages, employee relations. Under an expansive view of the joint employer doctrine, the franchisor could be liable for unlawful conduct, unlawful pay practices, unlawful NLRA activity at the local franchisee level. Over the last several years, this doctrine has had a tortured history. In 2015, the board issued the Browning-Ferris decision. And this was a broad expansion of joint employer liability. Browning-Ferris made new law in broadening the scope of joint employer liability. It got a lot of attention in the employment world, employment law world, in the franchisor world. And what the Browning-Ferris decision did, it found that the mere right to exercise minimal or indirect control over terms and conditions of employment, even if not actually exercised. So the mere right to exercise even minimal control created a joint employer relationship, and that with all the attendant liabilities that went along with that. So it was it's been a controversial decision, Browning-Ferris, but in 2015 that became the law. In December of 2017, under the new administration, under the new NLRB, the board issued what's called the Highbrand decision, explicitly and expressly overruling Browning-Ferris, reinstating the pre-Browning-Ferris, pre-2015 more employer-friendly standard. Under the Highbrand decision, it required actual exercise of meaningful control, not potential exercise of minimal control. So now the standard became actual exercise of meaningful control over essential employment terms for there to be a finding of joint employer liability. Employer must act directly and immediately, or one company must act directly and immediately in a manner that is not limited and routine. So a substantial reversal, in the business community widely hailed the Highbrand decision. However, so the result on the Highbrand is that joint employer liability will not be found where one entity has exercised only indirect control, has contractually reserved control that never exercised, or control that's only limited and routine. Sounds good for employers, sounds good for management practices. However, Highbrand is no longer good law. On February 26th of this year, the NLRB vacated the Highbrand decision. The NLRB Ethics Office, the Inspector General, found that the President Trump's appointee, William Emanuel, should not have participated in the Highbrand decision. Why? Because he was a partner at the Littler firm who represented the parties in the Browning-Ferris decision. And Browning-Ferris was still going on while this commissioner cast one of the deciding votes in favor of overruling it. And that was found to have violated his ethical obligations. And so the board vacated the Highbrand decision. And as of today, Browning-Ferris is back to being the current law on joint employment relationships. And so contractor, subcontractors, franchisor, franchisee, user, suppliers, parent, subsidiary, everyone now faces the broad joint definition of employer, broad definition of joint employer. However, on May 9th, the NLRB changed its approach and announced that the board is now going to consider a rulemaking process to determine joint employer status. So the NLRB just a couple weeks ago announced that a rulemaking process is underway. That's highly unusual for the NLRB. It's a rare means to establish standards under labor law. And if the board decides to publish a proposed rule, the public will have an opportunity to submit comments for consideration. So everyone will have an opportunity. We're not at that stage yet. They're having just announced that they're going to undergo this process. So to be decided, pay attention. We'll keep you advised. But right now, going forward, we're back to the Browning-Ferris. Lastly, I've got to wrap it up. There was a lot of attention in 2016 given to the new regulations on overtime rules. So the exempt status and overtime rules, you may recall that under the Obama administration, a new rule was issued that raised the minimum salary required to have someone be treated as an exempt employee from $23,660 annually to $47,476 annually. That was a big change, got a lot of attention. Employers, lawyers trying to figure out what to do about that. The net result of that rule, the final rule, would result in a large number of previously exempt employees now being reclassified as non-exempt, meaning that they would be entitled to overtime. So you had a whole class, thousands and thousands of low managerial level employees who were paid a salary, treated as exempt from overtime, who under the new rule would now be classified as non-exempt, be subject to getting paid overtime. Management didn't like it, employers didn't like it. Frankly, a lot of employees didn't like it because employees like being treated, for their own self-esteem, like to be seen as managerial employees, not keeping track of their hours, not getting overtime. But it has real consequences for what's a living wage and people being able to support themselves with one job. The rule came into effect, and immediately multiple actions were filed, 2 in the Eastern District of Texas, challenging the enforcement, challenging the legality of the final rule. And on December 1, 2016, a district court in Texas issued a preliminary injunction preventing the final rule from going into effect. In August of last year, that court issued a final judgment that the Department of Labor exceeded its authority and declared the final rule to be unlawful. That's where we stand right now. So all that publicity about raising the minimum salary and the salary basis test, that's off to the side. That's been enjoined from coming into effect. The current administration at the Department of Labor has indicated that it's going to revisit the rule. We don't have yet a proposed rule. Commentators who follow the Department of Labor closely expect that a new rule will come out and expect that the minimum salary basis will be increased, but not to the level that it was under the Obama final rule.